Hello and welcome. Today I am going to discuss the recent case and about the guideline issue by the Supreme Court. Complainant provided a friendly loan of Rs 600,000 to my acquaintance Kishore S. Borcar, who issued a cheque as repayment. Unfortunately, the cheque was returned due to insufficient funds, leading the complainant to file a prosecution under Section 138 of the Negotiable Instruments Act. In 2007, the trial court convicted Borcar based on the presumption that a signed cheque signifies a legally enforceable debt. The Sessions Court upheld this conviction in 2008. However, in 2009, the High Court of Bombay at Goa acquitted Borcar in an ex parte revision. Complainant then appealed to the Supreme Court seeking justice. The Supreme Court found that once the execution of a cheque is acknowledged, certain presumptions come into play. These presumptions indicate that the cheque was issued for consideration and to settle a legally enforceable debt. While these presumptions can be challenged, the accused must present credible evidence to dispute them. The court noted that Borcar failed to provide any evidence to support his claims against me. His defense was deemed unbelievable and absurd by the court. The Supreme Court clarified that even if a cash loan violates the Income Tax Act, it does not render the debt unenforceable under the NI Act. The court also criticized the High Court for overstepping its authority in this case. In the absence of a jurisdictional error, a revisional court cannot reassess evidence and overturn factual conclusions reached by lower courts. Ultimately, the Supreme Court annulled the High Court's ruling and reinstated the convictions made by the trial and sessions courts. Borcar was ordered to repay a 750,000 in 15 equal monthly installments of Rs 50,000 each to me. Recognizing the backlog of cheque bounce cases, the court revised the compounding guidelines to encourage early settlement. If the accused pays the cheque amount before recording defense evidence, the trial court may compound the offence without any cost or penalty. If payment is made after defense evidence but before judgment, compounding may be allowed with an additional 5% fee. If the cheque amount is paid during the appeal or revision stage, compounding may be permitted with a 7.5% fee. At the Supreme Court stage, if payment is made, compounding may be allowed with a 10% fee. These graded costs create a pay earlier, pay less incentive aiming to shorten litigation and ease the burden on courts.